Welcome to the Her Empowered Divorce Podcast. I'm your host, Beverly Price, and I am the empowering divorce coach who guides you on your journey before, during, and after divorce so you can eliminate pain, overwhelm, sadness, and anger, and create more knowledge, skill, and peace than I experienced myself. With my 30 years of divorce and empowerment coaching experience, I understand exactly what you're going through. Divorce is a difficult and emotional journey, but it can also be a time of growth and transformation. Through this podcast, you'll gain valuable insights on all aspects of divorce, from the logistical and financial to the emotional and legal. My goal is to empower you to confidently move forward in your divorce, manage your emotions, think clearly, avoid common mistakes, and ultimately create a happy and fulfilling life. With expert guests, practical advice, actionable tips, and inspiring conversations, we'll explore how to master your divorce and emerge stronger on the other side. You don't have to face this journey alone. Let's start together and create a better future for you. So without further ado, let's get started. Hi, beautiful. I'm so glad you're here today. As a domestic violence survivor, my passion is all around domestic violence awareness and recovery. October is Domestic Violence Awareness Month, and I'd like to share with you information to educate you. I've even formed something called the Divorce Coalition, where many divorce professionals have come together to use our influence to raise awareness and educate people as domestic violence. You can find the coalition at divorcecoalition.com and on Instagram at Divorce Coalition page. Well, today my guest is Joni and Larry Jones, and they are experts in domestic violence, both from an emotional and legal perspective. This episode is part 2 of their series. The previous episode we just recorded is part 1, where we talk about the emotional readiness for domestic violence victims for court. Today, we're going to talk about the legal readiness for victims for court. Hi, Joni. Hi, Larry. Thank you so much for being with us. I'm so excited for this episode.
Morning, Beverly. Thanks for having us, and we greatly appreciate the invitation to participate in your wonderful program.
Yes, thank you.
You're so welcome. To start off with, can you tell the audience just a little bit about yourself and your interest in domestic violence?
Sure. We used to live in New Jersey. We now live in New Mexico. We moved to New Mexico a couple of years ago. But while in New Jersey, I was a Superior Court judge in the family part. I was a domestic violence judge amongst my other duties, and heard countless and decided countless domestic violence cases. And before I was a judge, I was an attorney and represented many survivors of domestic violence in domestic violence court myself. And then after retiring from the bench in 2017, I became a teacher, a professor at Monmouth University, and we developed and taught a course on domestic violence law and social policy for undergrads and students who are interested potentially in going into that field, or just for their own personal knowledge. And also, while I was on the bench, I was on what's called the Faculty of Judicial College, which is the educating of judges on an ongoing basis, specifically on family court issues such as domestic violence. So have a lot of real life dealings with domestic violence and cases which appear in court. And here in New Mexico, we've become recently involved, Joni and I, with the New Mexico Coalition Against Domestic Violence, and just did a training program for persons who are representing themselves in court, in domestic violence court, some of the legal and emotional issues like we're talking about in this 2-part series on your podcast.
And my name is Joni Jones. I'm a registered nurse, board certified in mental health psychiatric nursing, along with being certified as an anger management specialist. And I worked almost 10 years on a mental health unit. I worked with many people that were either a product of domestic violence as a child, or they were going through divorces that resulted from domestic violence, and they were having continued aftermath of that. And on our unit, you had to meet the criteria of suicidal ideation. So I worked with very serious people with that. But I really had a connection because I had gotten myself involved in multiple domestic violence situations and relationships, and I was a product of a child with domestic violence, and combining the two just has given me such a passion, and being a true survivor, that I can come out and I could help other people get through their situations also.
We also, Beverly, want to thank you for focusing on the important issue of domestic violence. We know that October is National Domestic Violence Awareness Month, but it's a critical issue all 12 months of the year, obviously. So your program is going to help educate your listeners and others as a resource in the fight against domestic violence. So thank you for that.
Absolutely. And my hope is that these episodes not only help victims, but also help those who aren't victims stop condoning domestic violence through their silence. So, Larry, you're going to be more the expert on the legal side, having been a judge. Can you give an overview of kind of the process, the legal process in regard to domestic violence? And
Sure.
Is it a civil issue or a criminal issue?
Okay. Well, first of all, we live in a country where there are 50 separate states. And each state has their own set of statutes and rules. So no two states are exactly the same when it comes to really any issue. Some of the states' laws on issues mirror each other a lot, but there's no one uniform set of state rules that are exactly the same in all 50 states. So whatever state someone happens to be in, if they believe they are a victim or a target of domestic violence, it's really important to learn the law in the state. The first place I would look is the domestic violence statute or statutes. Sometimes there's more than one in your particular state. Because if you're getting, for example, advice from someone from New Mexico, and the laws are very different in Kentucky or Alaska or anywhere else, you have to know the rules as they exist in your state, procedurally as well as substantively. If you're not representing yourself and you have a lawyer, logically, if you go to a lawyer, an attorney in your state who has experience in domestic violence, domestic abuse in that state, they should be able to help you navigate through that process. If you're representing yourself, as many victims of domestic violence do, it's still helpful at least to go to an advocacy organization in your state, even if they're not lawyers necessarily, but they would logically have some experience in domestic violence and could help you navigate through the process. Because the court system in domestic violence court, and really in any branch of the court, can be overwhelming for people if they're not familiar with it. It's almost like learning a new language. Once you become familiar with it, you could become very good at it and even teach other people potentially. Many people who are survivors of domestic violence become domestic violence professionals in one form or another. They're lawyers who focus on domestic violence, and they've been through domestic violence themselves as a survivor in the past. It sometimes motivates them. But being able to, to at least, become a little cognizant and aware of what the laws are is certainly an important first step in the process, whether you're learning that on your own or through professionals who can assist you in that process.
Wow. And is it civil or criminal?
It's a little of both. See, and it gets a little complicated in certain areas of the law, but in general, to try to simplify it, it is possible that a domestic violence incident gives rise to both a civil and a criminal proceeding at the same time. So, for example, let's say in New Mexico, somebody, in a dating partner or a spouse or somebody in your family who's covered under the Domestic Violence Act, punches you because they're upset, they're angry for whatever reason. Well, that's an assault, obviously. A punch in the face would be an assault. So in most jurisdictions, that would be, an act of domestic violence. So what happens? What would happen is, logically, someone, the one who is victimized by that punch could file for a restraining order. Now, the restraining order itself, the domestic violence a complaint may be filed in family court. Like when I was a judge in New Jersey, I sat in family court. I was not a criminal court judge. I was a family court judge. That was civil. So the issue when I sat on the bench in family court was whether to issue a restraining order, but that was not a criminal court. Now, at the same time, the police could file a complaint against the abuser for criminal assault.
Gotcha.
And that would take place in the criminal courts in New Jersey. So you'd have two cases going on at the same time that arise from one single incident, from the same incident. And it's very important to focus on the differences between a civil case and a criminal case. Without turning this into a mini law school session right here, some of the differences are, number one, you're in two different courts. Number two, the burdens of proof are very different in civil court usually than criminal court. In criminal court, the standard of proof is beyond a reasonable doubt, whereas in civil court, it tends to be a much lower standard, preponderance of the evidence. In the civil court, it is the name of the case, the parties in the case would be generally the survivor of domestic violence, the plaintiff versus the defendant. So if it's John and Mary Smith and John hit Mary, the case would be Mary Smith versus John Smith. It's a civil case. In the criminal case, it would be the state of New Jersey or New Mexico or California versus John Smith. So there's a prosecutor involved or a district attorney involved. And so they kind of have more control over the case. And of course, the result of the case, in the civil case, there could be a restraining order and other financial consequences. In the criminal case, the result is somebody convicted of a criminal offense. So the statutes for domestic violence very often define domestic violence by looking at certain criminal acts, but the standard is very different. And so therefore, you could actually have two different results from the same incident in the civil case and in a criminal case. The most classic example of that is the O.J. Simpson case, where O.J. Simpson, was accused of murdering his wife in an act of domestic violence, his ex-wife. And it resulted, for those who recall, in two separate hearings, a criminal case where he was found not guilty by a jury because they could not prove guilt beyond a reasonable doubt in that case, the prosecutor, and then a civil case where the jury found that O.J. Simpson was liable for domestic violence, and it was like a $30 million judgment against him. Also, keep in mind that if you're in a criminal case, in a criminal system, it could result in a jury trial, whereas in a civil case, it may be simply a bench trial. You could also, meaning a judge decides it. You could also have a bench trial in criminal, but in my experience, it tends to be more jury trials as far as that's concerned. So you could have two different actions at the same time. You could actually have a third action taking place also in the civil court if the survivor of domestic violence brings a civil suit for damages for the assault against the perpetrator. That could be a separate case as well. That's not necessarily heard immediately in domestic violence court, or it could be an offshoot of the domestic violence case, and then you get a separate personal injury case, just as if anyone came up to you and hit you, it could result in compensatory damages or other forms of relief. So I hope that explains it a little bit.
Absolutely, absolutely. Now, what would be, from a victim's perspective, what might be some of the common misunderstandings about the legal process?
Well, as with anything, the more information you have, whether you're represented or not, usually the better off you'll be, at least in terms of the preparation for the proceeding. So a lot of times, survivors of domestic violence, in my experience, their appearance in court because they went and got a restraining order or applied for a restraining order, it's sometimes their very first appearance in court on anything. Not even a traffic ticket sometimes. Now, there are other people who've been to court 1,000 times on other issues, and just by going to court, they've picked up some of the procedural, mechanisms that take place in cases. But I can tell you from my experience on the bench that a lot of people who came in unrepresented, in good faith, seeking a restraining order, sometimes they conducted the proceeding in a way that it could have been better for themselves. So, for example, the lack of preparation. When I say lack of preparation, in domestic violence, it tends to be when you file a domestic violence complaint, the hearing takes place very quickly, usually by statute. So in New Jersey, for example, if you file a domestic violence complaint, the hearing's supposed to take place within 10 days. The social reason for that rule is because things shouldn't sit out there unsettled. If somebody needs a restraining order, there should be a final hearing as soon as possible. Sometimes it would take more than 10 days because there's an adjournment request or someone's got a lawyer and the lawyer is committed before another judge on something, so it can happen. But I would see people come into court and it wasn't their fault because they weren't professional attorneys and they weren't familiar with the process and they were just trying to get help. But nonetheless, they could have been more prepared had they been aware of certain requirements or expectancies in the court. So by way of example, sometimes people would come into court and they didn't bring in, and they have witnesses, but the witnesses aren't there. And the reason the witnesses aren't there is because either they weren't subpoenaed, or perhaps the witness, maybe it's a friend or someone who says, oh yeah, I'll be there, and then they just decided not to show up. So if you're going to bring witnesses for any particular reason, it's important to do what? To subpoena them so that they're required to be there. You're not just hoping they're going to be there and then they decide they don't want to get involved for one reason or another. So if you're expecting a witness, the witness doesn't show up, the judge might or might not grant your request for an adjournment. And if they don't, now you don't have that witness there to help your case. So that's number one. Number two.
Hi, everyone. As parents, we often have gut feelings when something just isn't right. And this can be especially true in co-parenting arrangements where one parent is struggling with addiction. If you're co-parenting with an ex who abuses alcohol, SoberLink can help. SoberLink's alcohol monitoring system is the most convenient, reliable, and reasonable way for a parent to provide evidence that they are not drinking during parenting time. The system's real-time alerts, facial recognition, and tamper detection ensure the integrity of each test, so you can be confident your kids are with a sober parent. With SoberLink, judges rest assured that your child is safe. Attorneys get court-admissible evidence of sobriety, and your kids are able to maintain healthy relationships with both parents. To sign up, SoberLink's offering $50 off your device for our listeners. Visit www.soberlink.com/empowered, and that will be in the show notes as well.
Particularly in current times, people tend to come into court with sometimes they've got all kinds of evidence. They have texts or emails or photographs or videos of certain things, and it's all on their cell phone. They come walking into court with their cell phone. And in this day and age, your cell phone is like a file cabinet in your pocket. But in court, it's very, very difficult to get evidence that's on your cell phone into the record. If you think about it, let's say there's a video of, that somebody had filmed of an abuser either berating or worse, hitting or punching a survivor, right? So you want to get that video in. Now, if it's on your tape, it's on your cell phone, there's just that one copy. The other side's entitled to see it too. How does the court then take that into evidence and make it part of the proceeding? Because you're supposed to make a record of everything in case something goes up on appeal if it's just on your phone. And while they could download it and they could do all kinds of things, usually in domestic violence court, at least in my experience, the courts are pretty busy. And they may have 10 or 20 cases in one day. And they can't, constantly be stopping a proceeding to accommodate the documentation that you may have on your cell phone. So it's very important to at least consider having available whatever you're coming in with on your cell phone. Also have, perhaps 3 copies available of everything. So there's a copy for the other side, a copy for the court, and then your copy, right? So then it could be marked and put into evidence. I'm not just talking about videos, photographs, texts, emails, any documentation, photographs of bruises, things of that nature. So it's important to come in with that, I would suggest, so that, the court doesn't have to be stopping the proceeding 100 times. Remember, there's 2 sides in every case, right? At least 2 sides. It tends to be. So if there's a no contact order in place, a temporary restraining order, and you've got everything on your cell phone, and you're not allowed to have contact with the other side. So that cell phone, every time you have something on your cell phone, it's got to be handed to the sheriff's officer, then handed to the other side, then handed to the judge, and you may have a whole bunch of people in the back of the court waiting their turn to have their case heard. And so it can make it very difficult sometimes if you do that. In terms of tape recordings, and certain states have rules that, they call it a 1-party state and 2-party state. So some states, if you're secretly tape recording someone, that's permissible as long as you are a party to that tape. And in other states, it's impermissible. So it's important to know, because a lot of times you have tape recordings of conversations between the abuser and the party, what the laws are in that state. If the laws require, or the laws in your state prohibit you from secretly tape recording someone without their permission, even if you're a party to that conversation, you want to know that in advance, because you don't want to get in trouble for doing something that's that's illegal, that type of a thing.
So
In your
where
particular
can they find those laws? Where can
Well,
they find out?
the one good thing about our internet age is a lot of things are much more readily available to people than they were back in the old days, where you'd have to go to a library or law library and look up the statutes. But even so, as we talked about on part one of your podcast, you got to be real careful if you feel that you're in a domestically abusive situation, and for example, if you're living with the abuser, you don't want to go online in your house to look up things about domestic violence, because it's extremely common for abusers to tap into that, to check your phone, to check your computer. It's not that hard to put taps on someone's computer to see what the search history has been. And so you want to be real careful. You don't want to make things even more dangerous for yourself. So you may want to,
Right.
go to somewhere where it's not on your network, a library, whatever it may be, or go down to an advocacy organization in your state. If you're unfamiliar with the law, but you think you're a victim of domestic violence, you think you're in that type of situation, it can be very helpful to consult in confidence with any of the, usually each state has, at least one, sometimes more, nonprofit domestic violence advocacy organizations. A lot of them are funded by federal funds under VAWA and other types of funding, and try to get some information about where you can get more information for trial readiness. If you have an attorney, the attorney would generally, you would think, would help you prepare for that. But if you're representing yourself, you still need to know these things, because if your witnesses don't show up, or your evidence is all on the cell phone and the court doesn't have is not willing to stop the proceeding 1,000 times to process that, you're kind of working against yourself a little bit, I would suggest. Knowing some basic evidence rules, even if you're not an attorney, is helpful, because even if you're going and representing yourself, you're still bound by the same rules as someone who is represented. So there are various rules, and sometimes the rules of evidence and civil procedure in each state, the book could be 1,000 pages long. But in my experience, a couple of the general rules where people get tripped up when they're representing themselves in domestic violence court is, number one, the hearsay rule. The hearsay rule means, with certain limited exceptions, you generally can't testify to what someone else said that's not in court to testify themselves, other than perhaps the other party. So, for example, if you have a friend who witnessed an act of domestic violence by the abuser hitting you, you can't come into court and say, my friend said that she saw this or he saw this. And the reason why that's inadmissible is because it's considered unfair to the process, because if that person's not there, there could be no follow-up questions by the other side or by the court testing their credibility. Where were you? When were, what specifically did you see? There's no cross-examination. So sometimes people come in with a written letter from their friend, or even certification, a notarized affidavit. It's still hearsay. You still need them there. So you really can't testify in general as to what someone else said. Now, like I said, there are some exceptions to those rules, but you really can't count on the exceptions as being the rule. They're exceptions because they are exceptions. You need to have the witnesses pretty much present as far as that's concerned. Yeah, John.
Beverly, I just wanted to add that some people go into court and they know their truth, and they feel like just because they're telling the truth, that it's going to be accepted as truth.
Right.
And
Exactly.
It doesn't work that way. And the other thing is, a lot of people, their frame of reference may be watching a television show about court, and they think that that's how it operates, and it doesn't.
Right.
So if they
Right.
do have the opportunity, if the court allows them to go in and watch somebody else's court proceeding and see how that operates, sometimes that becomes very helpful. Because a lot of times also what people do is they'll start talking to families and friends, and that may help in a situation of maybe bringing down an anxiety level, temporarily. But the advisement that's given can actually be fuel to the fire, because they're getting emotionally engaged themselves. They're getting revengeful, and they don't know how the court proceedings, operate, or how a judge comes to a decision. And that could actually hurt them instead of support them in the court setting.
Right. What Joni's saying is really, good information relative to the concept of perhaps going down and watching the mechanisms of some other domestic violence cases, as long as the court permits you to be in the courtroom. Sometimes a courtroom is closed for different reasons, if it involves a minor, things like that. But in other courts, even though it's a domestic violence proceeding, it's open to the public. So going in and watching how these cases work and seeing some of the objections and seeing some of the procedures can be helpful in advancing your own self-education on how these things work. Another thing I used to see all the time, people would come into court, they'd have their witnesses there, and they're going to call a witness, their friend, and then the witness takes the stand, and the plaintiff, the one bringing the request for the domestic violence complaint, they've got the witness on the stand, and then they don't know what to do next. Like, they don't ask any questions. They just expect the witness to start talking, and that's not the way court generally works. You have to, when you call a witness, you got to ask. They call it direct examination, and there's cross-examination. There's a way this works, and the judge can't be your attorney. The judge has to be neutral to both sides. So while judges can
such an important point.
Yes. So it's not that the judge is being, it's taking sides. In fact, they can't take sides. Sometimes people feel after a domestic violence case or any kind of case, well, the judge didn't do this, the judge didn't do that. And sometimes the judge didn't do certain things, and it could be that they should have done, and it could be appealable. But other times, it's not that the judge did something wrong necessarily. It's that the rules were not being followed by someone who was self-represented, or even sometimes when they had counsel, the rules aren't being represented. So if you're calling a witness, it's helpful to kind of know in advance what your questions are going to be. And also sometimes, so you can write them out. What are you going to ask the person? For example, were you present on, September 7th, 2019? What happened on that day? And even when you ask questions, not to make this too complex, but when you ask questions, there's certain rules on how questions can be asked. Without getting into it, there's certain things called leading questions, which are generally impermissible, and non-leading questions, and they kind of differ on direct and cross. And if you're not really familiar with this, and this is too much to get involved with while you're dealing with the emotional aspects of going through a restraining order against someone you may have previously trusted and perhaps even loved, that's why having an attorney or at least an advocate can be very helpful rather than trying to do it all yourself. Some people say, I can do this all myself, and maybe you can, but if you've never done it before, the risk of kind of messing it up along the way becomes greater. So, and some judges handle these situations very differently than others. You're not going to you could have present the same exact case before two different judges and get two completely different results, as well as two different approaches on how that judge chooses to handle the situation. So the more you kind of know about what's expected of you as a party in a case, even if you're self-represented, either by watching other cases or by consulting with an attorney or advocate or both, the better your chances are of being at least more prepared for what's expected of you in the process. You see?
For those women, in many cases with domestic violence, they're also suffering from financial abuse or financial control by the partner.
Right.
So the abused victim may not have access to finances to pay an attorney.
Right.
Are there pro bono resources for domestic violence victims, attorneys, and where might they find them?
Yeah. Again, each state is kind of its own little world to some degree when you're talking about state laws and domestic and state resources. So, for example, in New Jersey, where when I sat as a judge, there were many people who could not afford an attorney. So there were different possible options. You mentioned pro bono. It's possible you can get a pro bono attorney to basically represent you at no cost. There are also organizations, for example, if they're equivalent of legal aid or that type of thing, where you might be able to qualify if you apply for legal assistance. Although if in a civil case as opposed to a criminal case, there could be a different set of rules, financial dependency or financial challenges, etc. And then also, certain states, and New Jersey was one of them, they had in their statute a law which said that if, in fact, someone is a victim of domestic violence, the court can order counsel fees to be paid by the abuser. Now, each state handles that differently. And the issue in New Jersey, which was a little, sometimes created some ambiguity, is do you have to wait till there's a finding of domestic violence to get to have a reimbursement, basically, of attorney's fees? Or can a court order money to be paid up front by the abuser before there's any finding, as an advance, basically, so the person can get an attorney. Because some attorneys are willing to take cases, even if they're not getting money up front, representing a domestic violence victim, if the law allows them to seek counsel fees at the end. Some are willing to do that, just like attorneys sometimes will take a personal injury case if they're not paid up front, and that they call a contingency. You're really not allowed to have contingencies in family court in many states, but including New Jersey. But the statute does allow for a court to consider awarding fees. Also, if you're going through a divorce at the same time as a domestic violence takes place, which sometimes happens, because in the divorce, there are similar statutes which allow a shifting of attorney's fees. Perhaps that could be granted in the context of the divorce as well when a restraining order issue comes up. Not every state, to my understanding, and I'm certainly not an expert in all 50 states, and I haven't even been in all 50 states, but some states, to my understanding, don't have that type of provision in there, meaning that unless the person borrows funds from somebody and seeks a reimbursement at the end of the case or whatever it may be, they may have more difficulty than persons in other states seeking financial contribution, either at the beginning or end of the case, so that they can get counsel. I will tell you that, at least in my experiences in New Jersey, there were various organizations where people were willing to, supply a pro bono counsel, and even if they didn't have pro bono counsel, at the very least having an advocate, a domestic violence advocate. The difference between an attorney and an advocate really can't practice law or can't represent you or speak for you in court, but they can certainly help you through the process. So if it's a choice, if you can't afford an attorney, at the very least consider whether or not an advocate would be permissible to at least sit with you in the court so you can consult with them. And generally what you would do is you would ask the court first if that's permissible. You would always ask that you don't just want to have someone showing up there at counsel table who's not an attorney. But if it's explained to the court, that perhaps the judge will, in their discretion, allow that to take place if it's permissible in that jurisdiction.
Many people feel divorce is a death sentence, but with the right support and guidance, you can move through the process with knowledge, skills, and confidence. It can also be a time of growth and progress. As a divorce and empowerment coach, I'm an invaluable member of your divorce team. I help you understand and navigate the process, come to terms with your emotions, avoid costly mistakes, learn skills to help you communicate and negotiate, find your true voice, and create an empowered life post-divorce. If you're interested in learning more, schedule a free consultation at herempowereddivorce.com.
So there are options.
Wow.
Yeah, and Beverly, I'd like to add that if you're going in to court with an advocate, it's important to know how the judge makes decisions, because you have one person, the survivor that's telling her story, and then you have the perpetrator that's telling his story, and the judge has to make a decision on both presentations, because that's all the judge knows. And there's going to be certain criteria that's going to be looked at as responses, control, character, all these things to determine the credibility. And we don't know which way that judge is going to rule, because how many times do people come out and they say, well, I'm telling my truth and the judge is going to know, and then that doesn't happen. So one of the things that I like to, have people, if they have the opportunity, is to alert the court in advance if there are any things that can be interpreted, misinterpreted. So if somebody calms themselves by tapping or rocking or speaking loud when they get passionate, these are things that may be important so that somebody is not misinterpreted in their character, by the judge, especially, if somebody has, for example, high functioning autism, ASD1, formerly known as Asperger's syndrome, and they're going in there. Some of the common, characteristics, like maybe somebody doesn't have great eye contact, or maybe somebody's so traumatized that they can't even look at the perpetrator, in court,
Yeah, I think
and they're not
that's
making that eye contact. That could be misinterpreted of somebody, being evasive, not telling the truth, or if somebody's doing something, calming, like tapping a pen or their leg. It could be misunderstood as disruptive, and it's okay, to ask for a break if somebody needs something, because again, this is a very emotional time. But educating is very important. And I also always say, like, bring something calming. Like sometimes it might just be a picture of somebody, and it might be somebody significant in your life. Like maybe it's a parent that has passed on, or it might be a an object. It might be the type of clothing that you wear that is more comfortable for you. You may feel better if you take off your shoes. But if you're alerting that all these things are something that is making you comfortable in a very stressful situation so you can think and you can focus, those things become very important. And then the other thing that I'd like to share as a strategy is that if you have a writing utensil and a piece of paper, it's called effective listening. And there's going to be a lot of targeting from listening to your perpetrator twist things or blame you. And instead of having that, that emotional response, which is very impulsive, obviously, especially when it's a trigger to trauma, having a focus where you can just jot something down is twofold. Number one, that you won't be perseverating on your thoughts, so you won't forget what to say in response to what they say, because they're saying 5 other things while you're still focused on that one thing that's very important to you. Right. If you jot it down, and it's your turn to respond, instead of like interrupted or blurting out, you'll have your thought, and you might have 3 other ones that you have jotted down that if you were just perseverating, you would have missed those things. But the other thing is the act of writing it down takes your eyes off of the perpetrator, and it gives you something functional to do that does, by writing it down, it has a lot of therapeutic values. And it stops those emotional responses. It's an outlet that can be misinterpreted by the judge.
Right. And 2 follow-up points on that. First of all, your conduct in court, no matter which party you are, or really in any case, it does matter. And obviously you always want to be respectful in court and polite in court. Some judges get upset when they sense that someone is being disrespectful, but also, not to tell war stories, but there were cases I heard about from other judges, for example, where someone came in and they were crying, and they went on the stand and they were all upset and everything. And then there was, for example, a break. And then during the break, all of a sudden that person is being observed, that same person, of laughing and, rolling their eyes and having, it's completely different from how they presented on the stand, as if it was all, kind of premeditated or an act. And right. So you got to be careful. You're always being watched in court. You don't know who's watching you. It might not be while you're on the stand, but, when that type of thing happens, it could undermine your own credibility. So you always, laughing and joking is really not, appropriate in court unless the case is about, something funny. And domestic violence is rarely funny, never funny. And then also, a lot of people get confused. They say, well, I don't want to go to court, or I'm afraid to go to court because it's just my word versus their word. And a lot of times domestic violence, let's face it, we were talking about witnesses and stuff like that, but the truth of the matter is a lot of domestic violence by its very nature takes place with no witnesses. Right. At night, in a house, it's very private, it's domestic. There are some acts of domestic violence that take place in a public place, outside a concert or in a restaurant or in a bar, but the majority of them are really home-based and almost intentionally without witnesses around. An abuser might not want to be seen doing, beating somebody or being abusive. That doesn't mean you can't win the case. And as we talked about before, especially on the civil side and even on the criminal side, if it's one person's word versus another, and let's say you have a case where there's no corroborating evidence, it's just one, the survivor says He hit me. And then the abuser says, I did not. The court has every right to decide which side they believe by a preponderance of the evidence. So,
Right.
in many assault trials, many perhaps remember the Mike Tyson trial, where that was a criminal case. He had a date with someone and he, allegedly assaulted her. And then the jury found, even though it was just one person's word versus another, that he was guilty beyond a reasonable doubt. He went to jail, prison for 3 years. So on the civil side, when the burden of proof is much lower, you can still prove your case just by being more credible through your own verbal testimony. How do you be credible? Well, you come in a little organized. You know what you're going to say in advance, because if you come in and you're all nervous, and you could be very nervous for very legitimate reasons, but if you're not getting your story out there, it's not helping you. Right. So sometimes maybe writing some things, you don't want to come in and read off a piece of paper necessarily, but to have your notes, your key points that you want to point out written out, so that you can, if you do draw a blank because of nerves or whatever, you can at least fall back on that. You are allowed to bring in notes and refresh your recollection, as long as it's your own testimony, as long as you're not just reading verbatim from a statement, because that's not really testimony. That's just, you're reading a statement. And some judges may even allow that, by the way, but some may not. But having a few notes here and there is appropriate. In fact, if you have a lawyer, the lawyer will have a whole pad of notes. They don't just walk in cold. So if you're not a lawyer, if you're your own lawyer, you still have every right to do that. So you make sure you've hit on all the points you want to bring out. And practicing it in front of a mirror or otherwise is smart, because you get a little more familiar that way. And of course, when you walk into a court, it's a different environment than practicing in the mirror in your house, but it's still some element of rehearsal. It's almost like, actors or athletes, they have practices and practices all week long before they take the field. Why? So that when they get on the field, they're at their top of their game, so to speak. And so that's very important for lawyers or people who are not lawyers representing themselves. And being organized, having the specific evidence that you want to come out. And I would just suggest to anyone doing a domestic violence case, you can kind of break it down into at least 3 different sections, which is, number one, what is the immediate predicate act, the main act that drove you to seek a restraining order at that time? If the main act was from 10 years ago and you didn't do anything about it for 10 years, that's not as compelling in certain cases as if it happened yesterday. So you first want to focus on what's they call it the predicate act. And the second thing you want to focus in on is what's the history, the dynamic between the parties. Because you could have, if someone punches you in the face, you don't really need a history to say that that's domestic violence. But if someone, for example, says, I'm going to strangle you, that verbal statement standing alone might mean different things in different circumstances. Someone might say it just as a joke, even a bad joke, and they just meant it in a joking way. But if the person has a history of constantly saying that or abusing the person in the past, the court needs to know that so that they can consider that statement, that non-physical domestic violence, but a verbal threat, in the context against the backdrop of what the relationship was really like. So it's important to bring out the key elements of the relationship. That doesn't mean every issue that took place between the parties has to be repeated. There wouldn't even be enough time for that. But the most critical things, the things which you want, the most critical experiences of demonstrating domestic violence, you want to give that to the court so that they can consider the predicate act against that backdrop. You see what I'm saying? If you don't put that in there and you leave the court and say, well, nobody asked me, you missed an opportunity to educate the court on what the real dynamic of this relationship has been. And then thirdly, it's important to focus on how it has impacted you. How it is, in other words, some people, a threat is made, but they just walk on by and it doesn't bother them because they're not taking it seriously. And other times people are like, they can't sleep. They can't, they're afraid for their life. They're afraid to go to their job. They don't want to go anywhere, that type of thing. You have to let the judge know that, because the judge is not a mind reader. But if you're educating your job, whether you're representing yourself or whether you're an attorney, representing a survivor of domestic violence, is to educate the court, to persuade the court that, number one, that this is a legitimate domestic violence complaint, and number two, why it's important for the court to issue the restraining order. And that job falls on the party or the party's attorney to persuade the judge as far as that's concerned. The judge isn't just going to come up with that on their own.
And Beverly, I just wanted to just share with your listeners a strategy, because when the survivors going into court, usually at that time, they're fed up. And, now they want to have their justice for everything that's done to them. And there could be their own anger responses. And there can be very purposeful in the courtroom, since the perpetrator knows, your triggers, like the survivor's triggers, that they may try to just like hit on that. And I just want to briefly mention heartfelt forgiveness, because this is a strategy that can be very helpful in showing, your calmness and your presentation and not being baited in the courtroom. So most of us know forgiveness in the traditional sense, that one may minimize an act that happened against them, and they may have been hurt or have some anger from a person's or a friend's, actions, and they forgive them to the point where they're going to continue to have a relationship with them. But heartfelt forgiveness is quite different. You are forgiving, but there's no minimizing. What the person did will never be right. And you not necessarily want to continue a relationship with them. But there is a conscious focus to be free of the emotional burdens that have resulted from their actions. So I'll give an example. If we have somebody that their family member was murdered, and now the murderer is in court, and you see the family come in during their sentencing, and the family looks at them and they say, "I forgive you." It's not because what they did was acceptable. It's not that they ever want to build a relationship with them. It is to finally release themselves from the torment and the torture that is stopping them from going on with their lives and the trauma, so that now, that day after day, that torture has been holding them back. But now they are simply releasing themselves from the burden so they can move on and thrive once again as a family and find happiness. So whatever anger or hurt that there is, just push that pause button and remember what heartfelt forgiveness is, what it means and what it does, and then take that gateway towards that emotional freedom, because it's a very conscious act that can make all the difference in the world.
So the things we're discussing.
Well, we're about out of time. Sorry. We're about out of time today. So I want to thank you so much for being my guest today. This was so informative. It was just incredible. Thank you.
Thank you for having us, Beverly. And I just want to quickly indicate that we were, giving some examples of things. This is not meant to be all inclusive or the only things that you would bring up in court, or that this would necessarily apply in every single case. These are just some tips that you may want to consider. And like we talked about earlier in the podcast, it's usually pretty helpful to consult with an attorney or at least an advocate before trying these things out yourself.
Perfect. Well, all of Larry and Joni's information, as well as mine, will be available in the show notes. This and all our episodes can be found at herempowereddivorce.com on the podcast page or wherever you listen to podcasts. If you prefer the video version, you can go to our YouTube channel, Her Empowered Divorce. Join me for our next episode, where we'll be diving deeper during October's Domestic Violence Awareness Month of information that can help you on this journey. Remember that we also have part 1 to this, which is the emotional readiness of victims for court, in addition to today's episode of legal readiness for court. I have a free ebook, 24% of divorces are the result of domestic violence. You can find Why a Divorce Coach at herempowereddivorce.com/divorce coach. Until next time, stay safe and stay empowered. Thank you for listening to the Her Empowered Divorce podcast. Remember, divorce doesn't have to be a death sentence. With the right support and guidance, you can move through the process with knowledge, skills, and confidence. It can also be a time of growth and empowerment. As a divorce coach, I'm the first call you should make when you are contemplating divorce, as the next steps will take and set the stage for your entire divorce and life after. I help you understand